All right, we are continuing our coverage now of the Rachel Morin murder trial tonight, talking with an attorney about the First Amendment concerns raised today after the judge banned media from the courtroom for part of the proceedings.
Oh, joining us now is Patrick Seidel from Silverman Thompson. Patrick, what are reporters' constitutional rights during trials like this?
Yeah, what happened today is they were doing the voir dire process, which is the beginning of the trial, and the media absolutely has a right to be there. Normally what happens in a high-profile case such as this is accommodations will be made so that everybody can see what's going on in the courtroom and report on it. And apparently that didn't happen this morning.
Yeah, and that's really what we're used to being able to do. So this is certainly unusual. And so you're saying what happened today, is that actually breaking the law? Is there some sort of law for this?
I don't know if it's necessarily breaking the law. It's got some First Amendment implications. Sure. Obviously, the Fifth Amendment, the defendant has due process rights, and then there's the Sixth Amendment, which is right to a public trial and a fair and impartial jury. So they're doing the voir dire process, which is the jury selection process. And the media was trying to see what was going on, but I guess because of capacity concerns, they were forced to sit out in the hallway and have to listen in through the door.
Mm-hmm. So we know this could be a long trial. This was just jury selection phase. Could this have any impact on the trial itself, do you think?
Absolutely. Absolutely. What's supposed to happen is they're supposed to have some reasonable accommodations. It's fairly common in high-profile cases to have, at the very least, some type of overflow room where there's an audio and video feed going into another room. I think when you do something like this, when there's an allegation that people are being prohibited from being in the courtroom, the question then is it going to survive strict scrutiny? And the courts, if this is raised as an appellate issue, the courts are going to look at this and say, is there a compelling interest for the state to do what they did? Is it necessary for the proceeding? And was there a less restrictive means to accomplish the state interests? I think, we've seen from the judiciary already, they released a statement saying that nobody was prohibited from being in the courtroom. But the practical effect is if the media can't be in there during this process, then there's a real question about the transparency of the whole process in the trial. So it's certainly concerning.
Sure. And because it was so crowded in there, do you think this could be used to argue for a change of venue?
I'm not sure it's going to have much of an impact on the venue. The case is going to be tried where the crime took place, and this is obviously in Harford County. That's the appropriate venue. But the question still remains, is the attention and the high-profile nature of this, is it having an impact on the defendant's right to a fair trial? And I know from a defense perspective, they're certainly going to argue that because they're having these kind of unusual activities in the case, that it's certainly implicating his rights.
There'll definitely be a lot to watch with this, Patrick. Thank you so much for your knowledge, and thank you for joining us.
Absolutely.